Right. Okay. Well, let me do this first. For some reason, the sticky state, for some reason, the sticky note that was up here with the name of the person who has the ring, it's no longer up here on the desk. Somebody moved it. I'm sorry, on the bench. So do we have that? And I will call right away.
I will see if I can, we do not have this. But that was the property room?
Yeah, well, the person who has the ring in their property.
Oh. I think that is standby, Judge.
All right, thank you. All right. Are the parties here on Quinette Perry? All right, are you ready?
Yes, sir.
All right, if you come forward, please.
But is it like a reduction? Is it same? No, it's still. But I'm seeing other differences in that one. Yeah.
Probation, this is an application. Court is calling 2025 CR 005793 State versus Quinette Perry. Can I have parties announced?
Lauren Espinoza for the state. Tiffany Seagal from Miss Perry.
And is your first name Quinette?
Yes, ma'am.
All right, thank you. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Perry, did you review the application for community supervision with your attorney? Did you understand it
Yes, ma'am.
and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we are waiving the punishment enhancement.
Any objection?
No objection, Your Honor.
Ms. Perry, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property, $2,500, less than $2,500 with 2 or more previous convictions. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Perry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 1 year in the state jail facility. There's an $800 fine, and the state is recommending community supervision. Did you understand that to be the plea? Defense state.
Yes, Judge. Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Amelia Gomez or Angelica Gonzalez, and the anti-theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor, state offer State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, state you, and state in this case, there's no restitution.
No, Judge.
All right, state you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We're reading PSI.
All right. You want to explain to me, or maybe your counsel can explain to me, why are you doing this?
Your Honor, we believe, just based on the facts of this case, that's best to just go ahead and agree to the plea offer that the state gave us. As far as sentencing goes and accepting these terms, we think they're the most favorable to her. The last time she has been in trouble was in 2017.
Yes.
And she hasn't been in trouble since. She's been clean. She's been trying to take care of her kids. She's a full-time caretaker for her son, who has also mental health and behavioral issues. Her daughter has since learned her lesson. Her daughter is now an adult. She's no longer a juvenile.
But has she really learned her lesson? Because what I'm reading in the stipulation is she's the one who ended up pawning the bracelet.
Yes, Judge, at the direction of her daughter, Precious, but Precious has since,
Well, wait a minute. So during this time, how old was Precious?
I can speak. When this incident took place, she was 16. Her and the other little girl were minors. And
Okay,
this-
so Precious is 16 and Precious
now
told you
she's
to,
18.
yeah, no. But that at this time when Precious was,
Have an ID upon it. She was gonna give it back, but when the ISD kept pressuring her, she shut down. She didn't give it back.
and so she gave it to you and told you to pawn it. Okay, that doesn't make any sense to
To
me.
get her money back from the little girl that stole from her.
I don't know what's happening in this world. Because, no, here's the thing. As a parent,
You know,
if this other minor stole $20 from your daughter over the summertime, and what I'm reading in the stipulations, she didn't steal it. Another one of her relatives stole it, who's probably not a good parent or a good relative. And then your daughter decides to steal a Pandora bracelet from this little girl, which probably costs more than $20. And then I'm reading in the stipulations where they're asking you to get it back from your daughter, and you're like, oh, my daughter needs to calm down first. Do you even see how that my daughter stole somebody's bracelet, but you know what? I can't approach her yet. She needs to calm down. And then she doesn't calm down, and they're like, hey, you need to turn this bracelet over now. And you say, and then you tell them, well, you're not getting it. How about them apples? And then you're telling me your 16-year-old daughter comes to you and says, this is the bracelet. I need you to pawn it. And you being the adult in this situation is listening to your 16-year-old daughter to go pawn a bracelet that you know is stolen. Do you see?
it was 2 years ago, and like I said, when I made them choices back then, it ain't nothing like now. I made a wrong choice back then when I shouldn't have, like I told her, and like I was telling the other mom, me and the other mom, we got into it, we'll do it over. Instead of gave her money back, my daughter shouldn't have did that.
Well, according to the stipulations, the minor is not even the one who stole $20 from your daughter. It's some other relative.
It was the minor who did it.
I'm just telling you what's in the stipulations, what
Understood.
y'all
Okay.
stipulated to.
Yes, ma'am.
And even if she did it, I don't know why you would think 2 years ago that it would be okay to take this Pandora bracelet and pawn it. And how much money did you get for the Pandora bracelet?
$40 that she took from her.
No, according to this, it was only $20 that a relative took.
The girl stole it from my house and my daughter's room. That's what I was at. This, when my daughter took her bracelet, it was at school. When I was talking to the mom and the stepdad about this, they didn't want to hear nothing about it.
Your Honor, I believe at the time she thought she was writing her daughter, putting her daughter in the right and making her, even with the money at the, now in hindsight, wasn't the best parenting decision. It was in the heat of the moment. She's since learned that probably think about what happens before doing something so reckless, and she understands that now. We've had several long talks about this.
That's why Precious, yeah, her ass is getting a job. She's old enough now, she got something like that. She got,
See, we're still in the same position. Does Precious have a job?
no, she just got her ID just recently and now she's looking for a job. She has a job interview after this.
Yeah. There's going to be an $800 fine, 1 year in the state jail facility, suspended and probated for 3 years, 200 hours of community service restitution, no contact with Amelia Gomez or Angelica Gonzalez. And that's Gonzalez with a Z.
I believe so, Your Honor.
Oh, no, I'm saying that
Oh,
it's in Gonzalez. The anti-theft course. Field visits 1 time per month for 8 months. Proof of employment within 30 days. No employment as a home health care provider or with minors. TAP evaluation out of custody, follow recommendations, and the MRT. And no possession of firearms. And what are the ages of the children in your home?
28, 19, 18.
Okay. No unsupervised contact with minors. Probation, is there anything else?
UA reporting.
Thank you. Regular random UAs. Regular reporting by Zoom or in person. Anything else?
No,
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck.
Your Honor, if I may, the plea bargain was, you're in the state jail felony suspended for 2 years.
Now, this is what I always have to remind people. Anything below the line is not a part of your plea bargain agreement, and you're not allowed to enter into an agreement for a length of probation time or certain conditions of probation. The only thing you're allowed to agree to is we have an agreement that she's to receive probation or a fine. But as far as conditions and length, you're not allowed to agree to that.
Understood.
All right, thank you.
Thank you, maybe excuse?
Yes.
Thank you, Judge. Have a happy Mother's Day.
Oh, thank you.
What was that?
No. She didn't say anything?
Yes.
Yes.
Seems like
It's disappeared.
it's jewelry day, huh?
Yeah, it
Bracelets
is.
and rings.
I don't know. I want to go check this out.
All right, Norma
Yes, ma'am.
on Gomez. That's on page 2.
Yes, ma'am.
I want to say Robert Porter. He's
He's on another case and you're bringing that other case back on the May 7th.
yes. I'm sorry, May when?
7th, next Thursday?
Yes. So if you'll just put that for May 7th,
Yes, ma'am.
and Deputy Laura, you can send him back and let him know his attorney is in another case. Court, I'm sorry. All right, is the attorney here on Jessica Navarro? The attorney for Danny Cantu?
Yes.
Yes,
Ready.
yes. All right, this is an application. Court is calling 2025 CR 015820 State versus Danny Cantu. Can I have parties announced for the record?
Lauren Espinosa to the state.
Joanne De Hoyos for the defendant who is present.
And are you Mr. Cantu?
Yes, ma'am.
All right, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
And did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Junior proceeding on the lesser included offense of attempted possession of a controlled substance, PG two less than 1 gram.
Any objection?
None, Your Honor.
Oh, that's yours. Counsel.
Thank you.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the less included offense of attempted possession of a controlled substance. Penalty group 2, less than 1 gram. That's a class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 1 year in the Bear County Jail, $1,000 fine, and they're recommending community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense and state?
Yes, Your Honor.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, and the DOEP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not, I'm sorry, the lesser included offense. How do you plead? Guilty, not guilty, or no contest?
No contents.
State any evidence?
Yes, Your Honor, state offer State's Exhibit 1 and all attachments.
Your Honor, reviewed the same, signed it, and we have no objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we could.
Anything you wish to say on behalf of your client?
Just to let you know that he's checked with his boss, this conviction to be satisfied, he's going to keep his job, so he thanks the community for this opportunity.
All right. So the people who were in the vehicle with you, what are their relationship to you?
My girlfriend.
Okay. And if you're drug tested today, what are the results going to be?
Not really too sure. I might come out, I might be good, honestly.
When's the last time you used anything?
Like a little bit over 3 weeks.
All right. While you're on probation, you know you're not allowed to use. All right. And what do you do for a living?
I do construction.
And are you still together?
Yes.
All right. This is what the court is going to do. The court is going to sentence you to 1 year in the Bear County Jail, suspended and probated for 1 year. And let me just tell you, one of the reasons why I'm doing that, and your attorney will tell you this, it is so rare for people to accept responsibility of narcotics in the vehicle. Usually they have their girlfriend or their wife accept it, or either they say, that's not mine. So in the stipulations, I think you had already started forming, you were wrong for this because you said everything in the vehicle is mine. So it's going to be suspended and probated for 1 year. There's going to be regular reporting by Zoom or in person. There'll be regular UAs, random UAs. Make sure he's tested for levels. Is the only thing you're going to be positive for marijuana?
Yes.
All right, those levels need to start going down. And if there's a reason you're using that that's related to anxiety or some sort of mental health, let probation know so they can give you the help you need, okay?
Yes, ma'am.
Field visits 1 time per month for 2 months. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, 100 hours will be deducted.
Thank you.
The remaining 100 hours will be deducted upon completion of the DOEP course, which I'm ordering. There's to be a TAP evaluation out of custody. Follow recommendations, with the exception if they recommend inpatient treatment, we'll start with outpatient treatment. Let me see. Probation. Is there anything else? Oh, thank you. Proof of employment within 45 days, no employment as a home healthcare provider with minors. And I'm sorry, I forgot, $1,000 fine, and that will be probated.
Thank you.
Anything else?
Thank you for this opportunity. My client is fully aware of his responsibilities now.
All right, thank you. Is there anything else you need help with?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, yes, ma'am.
Because this plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Stay on the straight and narrow.
Yes, ma'am.
Thank you.
You're welcome. Vidalis. On page 4.
You know, Judge.
Hmm?
One time I was out with another lawyer. Another lawyer, a lawyer. And we got pulled over. He asked me to get in the driver's seat.
Judge, it was, Karen Corby's not here yet, Judge.
Reed. What page is Reed on? Oh, I see it.
He's on page 10.
Thank you. All right, so this is supposed to be a contested?
No, we have an agreement, Judge.
All right. All right, court is calling 2024 CR 007568 State versus Chaz Reed. Could I have parties announced?
Rick Banger for the state of Texas. Donald Wilson for the defense.
All right, and are you Mr. Reed?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Chaz Reed who was placed on probation in 2024 CR 007568 for a violation of registration on September 26, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 1. On or about the 22nd day of January 2026 in Bear County, Texas, the defendant, Chaz Reed, committed the offense of failed to comply sex offender duty to register life annual in violation of condition number 1.
How do you plead to that? True or not true?
State will waive the other violation, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. That is to grant the state's motion. Reform, thank you.
Mhm.
Conditions, sentence the defendant or revoke the defendant's probation or sentencing to 3 years TDC.
Is that the agreement?
That's the agreement.
Mr. Reed, are you asking the court to follow that agreement? Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will revoke, sentence you to 3 years in the prison. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
In your honor.
Yes,
Before we leave, I need to present this to you.
yes. Are you taking something in consideration?
Yes, Your Honor.
All right, what's being taken in consideration for the record?
The new.
Clause number.
2026 EF 06300.
All right.
Well, Judge, I think if the 299 BF number is being discussed.
Yes,
as well.
yes, Your Honor.
All right, and what is the other number? For the record?
2026 PF 06299.
06299.
Yes, Your Honor.
All right. Thank you. All right, is there anyone for reset, Norma?
Yes, I have a Theodore Garcia. And he's on page 6, one down. Judge.
Theodore Garcia.
I'm present for him, I'm sorry.
Can I jump off?
All right, Mr. Garcia, court is at 9. Good afternoon. Court's at 9 a.m. You got to be here at 9, okay?
Your Honor, I have something. I'm so sorry, Your Honor.
No problem. All right, today was supposed to be plea deadline date.
Judge, I'm standing in for Mr. Acevedo. I conferred with him. He indicated that he does have all of the discovery. I believe that they conferred with the state, and what he's asking is a referral for vet court.
All right, so I can tell you this with regards to Veterans Court. One, there can be a referral there. However, they don't do pretrial diversion, so he would still have to be on probation here. And Ms. Abrams?
Yes, Judge. I do want to make the court aware that, we did speak to Veterans Treatment Court this morning in regards to this case. He was a participant in Veterans Treatment Court previously. And they're just gonna look at it very, very closely. They're going to have to seriously consider, accepting him back. But they would, take the referral.
All right, and when are they gonna have a chance to review? Do they know?
Not sure, Judge. I have to get the referral to them.
All right, so this is what we're gonna do. This is gonna be recalled back on May 7th. They're gonna send over the referral. You'll need to be here on May 7th at 9 a.m. You understand?
Yes, Your Honor.
And then we'll see when they will have the referral done. All right, thank you. Once you sign the reset form, you're excused, okay?
Yes, Your Honor.
All
Thank you, Your
right,
Honor.
you're welcome.
Thank you, Judge.
Who else?
Jose Moreno, he's on page 6 at the bottom.
Jose Moreno.
Present.
Hello.
Thank you. Thank you, Judge.
You're welcome. All right. So in this case, there was an offer tendered. There was supposed to be some sort of disposition on April 15th in 2025 CC 016699.
Judge Edward.
Was it?
Well, I know there's an offer in the file that if you put on that case that they were going to dismiss this case. I was speaking to Mr. Martinez, who's his attorney on the DWI by text. He says he's out of town. I don't know what the details are. It shows that case was set for today, but he's out of town. There's no new setting as, you know, as if he got it reset. Mr. Martinez told me that his staff is contacting County Court Fee 14 about getting a date for him to go in and plead that DWI.
And that's our intention, Judge, is that if the plea is done in the misdemeanor, then this case will be dismissed. You know, in the next 7 months.
It's still shows 4:30. That's today, right?
Yes. So is it on the docket and what court is this?
County Court 14, Judge.
So is it on the docket in County Court 14 today?
It was set today, yes.
All right, so why hasn't that been taken care of if that's supposed to?
We haven't received word that a plea was taken in County Court 14.
Well, and I don't think it has, unless Mr. Martinez left later in the day. He's telling me he's out of town. I don't know where.
Is there only one prosecutor in that county court at law?
I know, Judge. In some of the misdemeanor courts, yes, there is only one.
So that court, what everybody is telling me is that court is not having court because they don't have a prosecutor.
Unknown, Judge.
All right, Norma, can you see if county court at law number 14 is having court today? Or if they had court?
Mr. Barrett, is it that Mr. Martinez is out of county today?
That's what he's telling me he's out of town.
No, that attorney is not
So
available.
it's not that. the
Oh,
state is
I
out of
thought he
county.
was saying the state, yeah.
Okay.
Oh, no, Judge.
It's like, what, there's only one prosecutor?
Yeah.
All right, and who is the defense attorney? Martinez who?
Lucas.
All right, so when is he gonna be back?
Good question. Can I call him, Judge?
Yes. You were scaring me there for a moment, or raising concerns.
Sorry about that.
I was like,
Answering your questions to the best of my ability.
it's like, yeah, sometimes we only have one.
Hey, Judge wants to know when you're gonna be back.
I was on my own in County Court 15 for a year.
Oh, wow.
You're getting back Tuesday? So you're back in the office Wednesday? Okay, he's back in his office on Wednesday, Judge.
All right, Norma, recall this for, well, let him know he needs to set that. Norma, recall this for, May 7th.
Yes, ma'am.
He's recalling it for a week from today. I want you to see about getting the County Court 14 plea done before then, I guess.
And this is the final plea deadline date.
One or the other.
Once you sign the reset form, you're excused. All right, thank you.
Sorry, no,
Thank you, Judge.
You're welcome.
thanks. All right, I just need to get you, sorry.
All right, Daniela Bustos, I think we took care of that. Let me see.
Sophia, click on her. Daniela.
All right, Deputy Laura, could somebody make an announcement for Daniela Bustos, please? And Mr. Behrens, are you ready to proceed on Bustos?
There's an offer in the file, that's all I know, Judge. I haven't been, this is third time she hasn't been here.
Oh, we're
I
gonna take
think
that
last
up
week
now.
he showed up 2 or 3 o'clock in the afternoon after I was long gone and
Yeah. All right, the court is gonna call 2026 CR 0025993 State versus Daniela Bustos. Can I have parties announced for the state
Brandon Prater for the state.
defense?
Robert Behrens.
All right, this hearing was scheduled at 9 a.m. It is now 2:28 p.m. The defendant has not made an appearance. Defense, have you had any contact with Daniela Bustos?
I have not, Judge.
All right, Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. Negative contact.
State?
Judge will be requesting a bond forfeiture.
All right, the court will issue a judge's warrant, remand without bond. All right, Luis Revele, what's happening with that?
Got the plea, if I'm not mistaken.
All right, well, who's ready?
I have a Victor Keonis.
Into the William drunk.
There's a plea on Victor Keonis.
All right.
Yeah.
All right, Jennifer Chambers,
I'll talk to you in a minute.
yes, sir. On that one, I just need a moment to call, okay, and I'll take it up.
Okay.
And state on Arnold Pena, Arnold Pena, how many witnesses do you have?
We have 2 witnesses, Judge.
All right, let's take it up. Mr. Blanca, you ready?
Oh.
Court is calling 2025 CR 010725 State versus Arnold Pena. Can I have parties announced for the record for the
Brandon-
state?
Brandon Prater for the state.
Defense? And you're Mr. Pena? All right, you entered a plea. According to your plea bargain agreement, punishment is to be assessed at a cap of 25 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. Have both parties had a chance to review the PSI report?
We have.
We have, Judge.
Any objections?
None from the state.
There are some factual inaccuracies.
Yes.
One of the greatest perhaps is that it lists him as having no dependents, so he has 2 biological children and some stepchildren as well that he takes care of. And so it's different than it appears on the first page of the PSI.
Okay. All right. State, any witnesses?
Judge, we have 2 witnesses.
All right, call your first witness.
Judge, the state calls Miss Lisa Chapa.
Mr. Pena, you're back against the counter.
Oh, thank you. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Lisa Chop.
All right, state, you may proceed.
I thank you. Miss Chapa, how are you related to Jalen?
I'm small.
Okay, and can you tell me, after the shooting, what was Jalen's condition?
He was in the hospital for about maybe 4 to 5 days. He had a 5.5-hour surgery that day.
Okay, was that the only surgery he had, or did he have to have multiple surgeries?
He's had a total of 5 surgeries, and he'll have another surgery when he turns 21 for major reconstructive of the upper
I'll take that up.
jaw.
Okay, so he's gonna have to have 6 surgeries overall to repair the damage? Or more?
Overall 6 surgeries, but he'll also have to have a couple of implants and some more other dental work done.
Okay. Lisa, I'm gonna show you what's been labeled State Exhibit 2, 3, and 4. Can you tell me what these are? These photos.
I did.
Okay, and looking at them, do they look like they've been edited? They're clear and accurate representations of what you saw that day?
They're exactly what I turned over.
Okay, Judge, the state would like to admit State Exhibit 2, 3, and 4 into evidence. Pending any objection?
No objection.
All right,
Permission to publish?
yes. States exhibits 2, 3, and 4 are admitted without objection.
Lisa, without going into, only going on what you know, not on what you've been told,
Mhm.
how has this affected Jalen mentally?
He has dealt with depression, anger, he's had nightmares. Every time he goes into like a surgical procedure, he has severe anxiety. He thinks he's not gonna make it out of the procedure. He worries if he's gonna die.
What was he like before this?
He's a very charismatic, carefree child, or was. He didn't know an enemy. He didn't have enemies. To him, everybody was his friend. There wasn't a such thing as bad people. He could go, and this is gonna sound horrible, he could go to a funeral and not know anybody and then come out and everybody was his friend.
Very gregarious, very friendly.
Very friendly, very charismatic, go-getter.
Is he like that now?
No, he's more reserved.
How old was he when the shooting happened?
He was 17.
17? Okay, so it wasn't 18 yet.
No, he was not.
He was still legally a child.
Yes.
Okay. I'm gonna ask you. So the offer right now is what's called a cap offer. It means it's a cap of 25 opposed. That means the judge can sentence all the way up to 25 years.
Yes.
She can also sentence what's called deferred adjudication, which means that Mr. Pena would be on supervision, but he would be out in the community.
Yes.
I'm gonna ask you, in your opinion, because the complaining witness is your son, what would be the appropriate punishment for what Mr. Pena did to Jalen?
That invades the province of the court.
Right, that'll be sustained.
Thank you, Lisa. We'll pass the witness.
He was 17 at the time.
Yes, sir, he was.
And as I understand it, he had been downtown partying with his girlfriend all night and then went from downtown to her house. And then at 5:30 in the morning, he was finally coming, home back to you, or where was he going at 5:30?
He was coming back home.
So did you, I mean, am I correct? He'd been downtown partying that night and then,
He left the house. He was typical 17-year-old who thinks that he knows everything and doesn't have to listen to the rules that he had in home. He picked up his girlfriend. They were hanging out. I don't know where they were hanging out at. I know that at one point he came home. I told him he needed to take her back home because I didn't approve. And he left. I was assuming to drop her off at home. And that's all I know. And then he was on his way home at the time he was shot by the defendant.
is the location that where this allegedly occurred somewhere between his girlfriend's house and your house?
My house.
It's close to your house?
Yes.
And the downtown, I wasn't trying to put words in your mouth. I got the partying downtown was stuff he said in the PSI. So that's where, in the police report. So that's where I got that from, just in case you were thinking I was not being straight with you. So your testimony is he had been out all night, came home. What time did he come home to your house with his girlfriend?
Probably about 10:30 or 11. And I told him he needed to go home because it was not appropriate. And he needed to take his girlfriend home. And he said he was, and he left.
And what time? And
It was about probably 11:30.
so from 11 to 5:30, where was he? If you know,
I do not know, sir.
did you ever ask, inquire?
No, because when all this happened, that was not my top priority.
Okay. And you're aware that perhaps his driving also played a part in this,
Objection, Judge, beyond the witness's personal knowledge.
if she's aware?
All right,
I am
that'll be
not-
overruled.
Okay, that's all I have.
All right, thank you so much. Call your next witness.
Judge, the state will call Mr. Jalen Chapa.
Hello, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jalen Chapa.
All right, you may proceed.
Thank you, Judge. Jalen, how old are you right now?
I'm 18,
Okay, and how old are you on the day of the shooting?
17.
All right, so walk us through that day, man. How did it start? What happened?
Okay, so at the beginning of the night, I wasn't listening to my mom. I had left to go get my girlfriend, and I picked her up, brought her back to my house. My mom didn't want her there, so I left. And when I left, I went downtown. I was not partying. I didn't have any substances in me, nothing. I was downtown for maybe 2-3 hours, and then I took my girlfriend back home. She doesn't live over here, so I took her back home. And taking her back home, that's about an hour and a half drive. So I took her home, and then I headed back to San Antonio, and I had got on Highway 90. And when I got on Highway 90, I had driven down Highway 90 about a mile. A mile after Highway 90, the defendant, he came up driving real fast. And on the side of me, there was another 18-wheeler. There was an 18-wheeler. On the other side, there was another 18-wheeler. I was in the right lane. And when I was in the right lane, he tried pushing me off the road off to the side so we could get
And
past.
when you say he, like pronouns are like, let's not use pronouns. Who was he?
The defendant,
Okay, Arnold Pena?
Arnold
Okay,
Pena.
so let's use Arnold Pena. So Arnold Pena was trying to push you off to
He
the
was trying to
median?
push me off to the median so we could get around.
Okay.
I didn't have a chance. I wasn't gonna go onto the median because I wasn't gonna ruin my car. So I kept driving.
Was it,
and
what kind of median was it? Was it like a concrete median or
It
a
was
grass
a,
median?
it was a concrete median that turned into a grass median.
Okay, all right, keep going.
So I was driving. I didn't let him over because there was no way to let him over. At that point in time, I did roll down my window and I put my hands out the window because I didn't know what was going on. I had never encountered anything like this ever.
When you put your hands out the window, what kind of gesture was it like?
I was like
What's
that.
going on?
And Right after that, a couple seconds later, I'm looking at a gun. He goes on his lap, he pulls out a gun, he's pointing at me. So after that, I speed up. I get around traffic. I go down Highway 90, and at that point, I thought I had lost him. So I was going down Highway 90. I look in my rearview mirror. Somebody's speeding up behind me. I look over, it's him. So I just let him pass me. He gets in front of me. I'm like, okay. So at that point in time, I tried taking a picture of his license, but I couldn't because I was driving. So I got his license plate number. I texted it to my girlfriend. After I texted it to my girlfriend, I missed my exit. So I had just tried going by, but I was recording just in case anything happened. And as soon as I get next to him, I get shot.
Okay. And did you have your phone in your hand when you were shot?
I did, yes, sir.
Do you happen to have the phone that you had that day?
I do, yes, sir.
Can you show it to the court?
I don't have it on this. May I grab it?
Yeah, go grab it.
The phone that I had.
Okay. For purpose of the record, can you describe the color, the look of it, shape?
It's a light blue phone, has a clear phone case. I mean,
And when you were holding it up, were you recording on opinion?
I was recording, yes, sir. I was recording.
Can you demonstrate to the court how you were holding
I
it?
had my phone out the window like this.
Okay. So,
And
so it's with the light side facing outward like
yes,
that?
sir. It was like that.
Okay. So did you ever honk at Arnold Pena's vehicle?
I never once honked.
Okay, and why is that?
My horn on my car it doesn't work right.
Okay.
It doesn't work right. So for me to be able to honk, I have to go full force honk.
Okay.
And I don't honk at all. If I'm being completely honest with you, it's just I don't honk.
Okay. When you at any time when he first flashed the gun at you to when he was back alongside you, were you driving aggressively towards him?
No, sir.
Were you swerving into him?
No, sir.
Were you trying to goad or provoke him into something?
No, sir.
Okay. Where'd you get shot at?
In my face.
Can you show to the court where the entry wound was?
It was right here.
Okay. So that's about, if I may, it's about 4 inches from your forehead. Is that about right?
Yes, sir.
Okay. After you got shot, describe what you saw, what happened.
Okay, so right after I got shot, everything went black. So I didn't know what was going on. I was out of it. I came back to it, but I couldn't see. Like my vision was completely blurry. I couldn't see anything. And it took me a couple of seconds to come back because everything went black. And when it came back, it looked staticky. So I come back and I realized I had got shot. And when I had realized I got shot, I freaked out. I really did. I started crying, I freaked out, and when I had opened my mouth, my whole jaw, like the whole top of my mouth, had fallen in my mouth. So I was like, oh, okay. And when I looked over, Arnold Pena was right there next to my car. And
So you saw him after you got shot?
I saw him. He was right next to me. Yes, sir.
What did you do?
I had asked, like, I started crying. I didn't know what to do. So I had asked him, I was like, bro, you shot me. Like, can you please help me? And
what did he do?
He just drove off. He looked at me and drove off.
After you asked him to help you?
Yes, sir. He sped off.
What happened next, man? When he drove off?
I pulled over. I got out of my car. I collapsed on the highway. I forgot to put my car in park, so my car went off the highway and it smacked the wall. And when it hit the wall, it turned around and ended up in grass. And after that, I had fallen again. And so a group of it was a garbage truck, they had pulled over to help me. And at that point, I was desperate. So I got up and I ran to them. I was trying to get help. I didn't know what to do. I was close to home, you know what I mean? I got my mom and I got my little brother at home.
Yeah.
So I was trying to get help. Like I had no way to get help at all. So I ran up to them. They tried helping me, and as soon as I ran up to them, the sheriff showed up.
Okay, what happened next?
When the sheriff showed up, they called the ambulance. I asked them for water. They said no, I couldn't. because of the condition I was in. So they
Why
had me
couldn't you
sit,
drink the water?
my mouth, it collapsed.
Okay.
Everything was coming out of my face because it went in and it came out. So I was bleeding out from my whole face. I couldn't talk right. Like I was able to tell the police officers like where I lived, my mom's name, my name, that kind of thing. And after that, I mean, I don't really remember much. I mean, I remember getting in the ambulance, and after I got in the ambulance, I don't remember much other than I woke up at the hospital. When I woke up at the hospital, I had already been sitting there for 2 hours, I guess, and I got to a point where I started throwing up blood.
Yeah.
I mean, they rushed me into surgery. They had to pull a bunch of my teeth because I lost a lot of teeth. They did that, and then I went into surgery. I didn't wake up till like a day later. They had put me in a coma because I had a really harsh surgery. I was in surgery for about 5 to 6 hours.
Okay.
And then right after that surgery, I think 2 weeks later, I had to go to get another surgery. And then after that, surgeries just kept coming and coming and coming.
Yeah. How many surgeries have you had to have?
Recently, I think I had five or six, but I had a surgery to get my jaw fixed because my jaw was shattered. So they had to fix my jaw. So my mouth was wired shut for a month. After that surgery, I had to go get a surgery for the roof of my mouth because the roof of my mouth wasn't there.
Mm-hmm.
So I had to get that fixed because there was a big hole in it.
So you basically had to have your whole mouth reconstructed.
Oh, and it's still not fixed. I may look fine, but I'm not.
It's still going.
It's still going. I still got more surgeries ahead of me. I mean, they told me at my last visit that the hole in my mouth may not be closed, and it's causing me to have sinus issues.
Yeah.
So they said that's a possibility. Then I have to get implants, and when I'm 21, I do have to get another surgery for my mouth again. They don't want to do it now because of how many surgeries I've been through already.
Yeah.
And because it's a pretty big procedure. So they want to wait till I'm 21.
Okay.
Yes, sir.
Let me ask you, man, that scar right there, it's still pretty fresh. Do you think that's ever gonna heal?
No.
It's gonna be there forever?
Yeah. The doctors, yes, sir. The doctors already told me that it's going to be there. It's not going to go anywhere.
Okay. To be honest with you, man, how's this affected you mentally, man? Are you sleeping? Have you been to therapy?
I mean, I went to therapy for a little bit.
Yeah.
But honestly, I'm not the therapy type of person. So I can't go and talk about my feelings. I'd rather just hold it in. And when it gets to me, it gets to me. I let it all out at once. And it's not the healthiest thing, but that's what I do. And mentally, I'm all over the place still to this day. I mean, there's a lot of things that have gone through my mind, and it's just, there's times where I do think, like, I don't want to sound brutal, but there's times I do think that bullet should have taken my life. Because all the stuff that I've had to go through, I don't want to go through, and I don't think anyone should have to go through.
Yeah.
So there's times where I do think to myself, and I'm like, I'd rather be dead than be dealing with all of this.
Well, this isn't a question, it's a statement, but like, go to therapy, man, and don't make a permanent choice for a temporary solution, all right?
Yes, sir.
So it sounds like you're gonna be recovering from this for a while
Yes, sir.
and possibly never recover fully.
Yes,
And
sir.
how old are you again?
I'm 18. I just turned 18 in October.
And you got your whole life ahead of you, right?
Yes, sir.
Judge, I'll pass the witness.
Defense.
So let's start, you're not a therapy kind of guy. You hold it in and then it just comes out.
Yeah.
You just lose your temper or something.
I don't lose my temper. I just cry.
Okay. Now that night, you said you were at your mom's house with your girlfriend.
Yes, sir.
And then where did your mom live? Don't give me an address, but what part of town? How far away from downtown did she live at the time?
15 minutes.
15 minutes. And then you left her house and y'all went downtown.
I went downtown. Yes, sir.
And in the police report or whatever you said, we went and partied downtown. So what'd y'all do? I mean, you
I
can't get
drove
into a club. You can't get to a
I
bar
drove around downtown.
for 3 hours.
Yes, sir.
Y'all never got out of the car. You just saying you just drove
I
around.
mean, I got off the car to go to the gas station. That's about it, sir.
Okay. And then you said she lived an hour and a half away. Where did she live?
I'd rather not answer that.
Not the address. What city or what direction?
She lives near Floresville, past Floresville.
Past Floresville. Okay. So you'd been out all night with her,
Yes, sir.
dropped her off, and you're still out, and it's 5:30 in the morning when Mr. Pena is going to work,
Yes, sir.
and you're coming home from a night out,
Yes,
right?
sir.
Okay. Now, you gave a different version today of what happened to what you told the police and what you told the pretrial of this PSI officer. So you said today, in this version today, that my client got behind you, tried to push you off the road. Did he ever did his car strike the back of your car?
He
I
did
don't
not-
object to that. Under 613 with the prior consistent statement, certain predicate needs to be laid out. Mr. Bunk has not laid that predicate.
All right, that'll be overruled. You can ask the question.
You said he pushed you off, did he strike the back of your car?
He did not.
Or did he just get up close behind you?
He got up close to my rear door.
Okay, and that's when you did you raised your hands?
Yes, sir.
Okay. Now, you said, and at that point, you said you were able to get around him and you drove off thinking you had lost him.
I didn't get around him. I got around the semi trucks. I sped up so people would sped up. I mean, honestly, I don't want to be staring at a gun. I don't want to be anywhere
Well-
near a gun.
You got past him and you drove off, right?
Yes, sir.
You told the judge a minute ago, you thought you had gotten away from him, you drove off.
Yes, sir.
Now, in the police report, you say the only reason you passed him was because you couldn't see what he looked like and you wanted to get a picture of him. So you pulled around and you got in front of him and you tried to take a picture of him. That's different from what you said today.
Yes, sir.
So which one actually happened? You got in front of him and slowed down so you could try to take a picture or whatever you were doing with your hands, or you spread off and he somehow caught you?
This was two different events, sir. He pulled a gun on me multiple times.
After you say he pulled the gun from his lap, and you don't know where it came from, right? You didn't see it come from his lap. You're just assuming that's where it came from, right?
Yes, sir.
Okay, so you said today, in this session today, after that happened and you saw the gun, you were able to get around him and you drove off and you thought you had lost him.
Yes, sir.
Okay. Now, in the police reports, you say, when I got around him, I slowed down because I wanted to get a picture of him so I could see what he looked like.
Yes, sir. I slowed down to take a picture of his license plate. Yes, sir.
So when did that happen?
That happened right before I got shot, moments right before I got shot.
So you're saying you sped off and drove off,
Mhm.
but some guy's pulled a gun on you, you've driven off, and then somehow he catches you,
Yes, sir.
and you weren't doing anything.
No, sir.
Okay. And then at some point you take something out of your lap and stick it out of the window in your hand, right?
Yes, sir.
And it's 5:30 in the morning, so it's dark
The sun was out, sir.
at 5:30.
Yes, sir.
What month did this happen?
It was 6:30 in the morning, sir.
January at 6:30? You're saying it was light.
Yes, sir.
Okay. So you take something out of your lap, hold it out of the window, right?
Yes, sir.
Because at that point you say right before you got shot, you were trying to take a picture of him.
Yes, sir.
So he reacted to what you did. You take something out of your lap, stick it out of the window, and right after you did that is when he shot you. Is that what you're saying, correct?
I had my phone out of the window the whole time.
Well, not the whole time, because you drove off and lost him.
Yes, sir.
Okay.
But when I got his license plate,
Now, another thing is you said today is, as far as I know from having read the reports and the PSIs, this is the first time I've heard about how you stopped and he stopped beside you and y'all talked and then he drove off. That's not in the police reports anywhere.
okay.
Is that something you just remember, or is that something that didn't really happen? It just sounds better.
No, I didn't mean by he physically stopped. I was on the highway when I woke up. I was still driving, and I looked over and he was right there. That's what I meant.
Okay, so you made it sound like you stopped and he stopped,
No,
because
no.
you said, and then he drove off.
Well, he took off. Yes, sir.
Okay, all right. And you're saying this all happened on Highway 90? It didn't start somewhere else and end up on Highway 90? Are you sure?
If I'm being honest with you, I don't know
Please
my
do.
highways like that, but
Okay.
I know the highway that I have to take to get home from my girlfriend, and it was Highway 90.
Okay, so and if that's the case, then this all happened on Highway
Yes, sir.
90. Okay,
Yes, sir.
all right. All right. That's all I have, Judge.
No further, Judge.
All right, thank you.
Thank you, ma'am.
You're welcome. Call your next witness.
State resting close.
Defense, any witnesses?
Yes, Judge. I'm gonna call my client, Judge.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so I can hear and the court reporter can hear.
Yes, ma'am.
All right, if you state your name for the record.
Arnold Pena.
All right, you may proceed.
Okay, now, Mr. Pena, let's start with you and I have only met recently. I mean, within the last couple of months, is that correct?
Yes,
I
sir.
wasn't your lawyer at the time you entered this plea, right?
Yes, sir.
And we, earlier today, we concluded a motion to withdraw your plea and we're at the sentencing as a result of the judge's ruling. Is that correct?
Yes.
Okay. Now, you and I, after that, had a chance to go through what's called the pre-sentence investigation, which is the document I'm holding now. And you and I went through this in its entirety, correct?
Yes, sir.
And that's where you pointed out to me that you actually do have some children.
Yes, sir.
Now, on page 2, it seems to indicate that you've never been arrested for anything in your life prior to today. Is that factually correct?
Yes.
Okay. Now, let's rewind, if we will, to that morning. Do you remember that morning?
Yes, sir.
Okay. So what, were you just coming out from a night partying all night with your girlfriend, or what were you doing at 5:30 in the morning?
I was waking up on my way to work.
And what time was it when you had your contact with this person, if you remember? I said 5:30. He seems to think it was closer to 6:30.
5:30, 5:45.
Okay. And you know that because of what?
Because-
Where were you going?
Going to work.
And what time do you normally leave your house to go to work?
It's 6 o'clock. 6:30.
You leave at 6?
Mm-hmm.
So this happened after 6, or? See what I'm saying? We're not sure. As far as if you do you leave your house at 6 in the morning? So this happened shortly after that, or had you already left your house to be at work at 6?
You know, yes. I
Which
woke
one?
up-
I'm sorry.
I woke up at 5.
And the job that's listed in the PSI about the heavy equipment, is that the job you were going to that day?
Yes, sir.
Okay. Now, tell us your first contact with this individual.
It was right before General McMullen. I was on the lane before the fast lane.
And when did you first recognize another car that was involved, the other car that was involved in this?
Shortly after, I tried merging to the right lane because the fast lane was congested.
And when you said the fast lane, that's the left
Left
lane,
lane,
is that
yes,
correct? Okay.
yes.
So you were merging back into the right lane, and what happened?
I heard a honk. I merged back to my original lane, which is one lane away from the passing lane. Black Charger pulls alongside me and waving his hands in the air.
Okay, and what did you do as a result of that?
I continued. He swerved into me. I did the same as I swerved back into his lane. I saw motion in his hands. He was reaching for something, so that's when I merged. Looked over to my left side to the fast lane. I saw a small gap, which I cut somebody else off on the fast lane and took off, avoiding the situation.
Okay, now he's told the court the exact opposite, that there was a confrontation and that he moved over and left you in the dust.
Mm-mm.
Is that correct? Is
Yes.
your record? No, that's not correct. Okay. Now, at some point, there was an incident with the gun. Is that we've pled, you've pled to this offense. You understand that you've been charged with aggravated assault and you've pled to that.
Yes, sir.
So there was an incident with the gun that resulted in the injuries he's described. Is that correct?
Yes, sir.
Okay. But at the time, and describe how light is it out there at 5:45, 6 in the morning?
Not very much. The sun's not barely breaking dawn.
And where when you said it was on General McMullen, is that different than Highway 90?
No, it's the exit.
Okay, McMullen exit, it's on Highway 90, but at the
Yes.
General McMullen exit.
Exit, yes.
Okay. And how far do you think you traveled with this other car before something happened?
Almost I would say 1.5 to 2 miles.
Okay. So a couple of minutes, this whole ordeal lasted a couple of minutes.
Yes, sir.
Okay. Now, what would you like to, was there anything what would you like to tell the judge? She has to make a decision that's going to affect you obviously tremendously.
Yes, sir.
You've asked for probation. I've explained to you, if you were to get probation, the big part but that is making sure he is financially satisfied with all the money he says he's owed,
Mhm.
whatever victim compensation didn't pay to him,
Mm-hmm.
those types of things. You understand that, correct?
Yes, sir.
And now your children, I've mentioned that the PSI doesn't reflect it, but you have 2 children. Tell me about them.
Avani's 11 years old, and Azra's 9 years old. I pick them up. I literally just picked them up the weekend before this incident happened. Me and the mother of my children, we have a good co-parenting.
I pick up my kids every weekend, and I have not missed. The last 9 months has been kind of rough for me because I've already missed so many weekends without their.
When you say 9 months, have you been in jail for 9 months?
I'm about to hit 10 months.
Okay. Okay. Now, you mentioned also a 17-year-old stepdaughter.
Yes.
Tell me about that.
Aaliyah. She's amazing, man. I've been in her life for the last 4 years. She's told me that I'm pretty much her father, which kind of hits me a lot. Just knowing the fact that I've been there for her life for 4 years. I've been in her graduation, her events, at school events. And so when this incident happened, it really touched down on me because she was 17 at the time. That's also she was about to turn 18 in August.
What else? Is there anything anything particular you'd like to tell the judge before she makes this decision that we haven't already discussed?
I wish none of this would happen. I really do.
Yeah, that's all I have, Judge.
All right, any questions?
You, Judge. Benny. So you were saying before that you were justified in this. Why'd you leave him on the side of the highway?
I panicked. I freaked out.
Why'd you panic, man? If you were in the right, why didn't you stay to help?
I don't know.
Who'd you tell about this?
But other than my girlfriend.
Who's your girlfriend?
Elizabeth Gonzalez.
Are you sure?
Mm-hmm.
Should it ask that you take judicial notice of the stipulated evidence, specifically page 9 of 14 on Sean O'Neill's report. And since it's stipulated, I'm going to read into the record. It says here, according to Elizabeth, Arnold never mentioned anything about a road rage disturbance and does not know what we are investigating. Elizabeth has no idea what you're talking about. So you've just lied again.
I object. He didn't ask him when he told Elizabeth. He's had the last
My question was
10 months to talk to Elizabeth and tell her about what happened. So if he wants to say, did he talk to anybody about it right at the time, and let him say no, then he can accuse him of not being honest with the court. But until that, there's no reason to believe he's being dishonest with the court.
when did you tell Elizabeth?
Shortly after I was incarcerated.
Okay, so not before August or July?
No.
Okay. So it was after you got arrested was when you finally told her?
Yep.
Okay. Did you call 911?
No, sir.
Did you report that there was a shooting?
No, sir.
Did you report that someone was trying to run you off the road?
No, sir.
Did you report this to anybody?
No.
If you were justified, why not, don't hide, advertise? Why didn't you tell anybody if you were in the right?
I don't know.
Okay. Let's go to page 13 of 14 in the state stipulated evidence. Did you still have the firearm that you shot Jalen with?
I do not.
You did it?
And I don't have it anymore.
Okay, did you have it before you were arrested?
Before, no.
How long did you have the firearm?
The day after.
Okay, did you get rid of it?
Not technically.
Okay, well, enlighten me. How did you get rid of it?
I just put it a different different location on my person.
Okay, did you manipulate or do anything with the weapon?
No.
Okay, because in the report, it says that it looks like the handgun and the magazine were wiped down. No fingerprints or GSR could be recovered because it had been cleaned. Did you clean the weapon?
No.
So you fired that gun, did nothing with it, and then magically there's no gunshot residue or fingerprints of any kind on it afterwards.
I object once again. It's assuming facts, not evidence. It's assuming that's the same gun. And if they have evidence that's the same gun, that wasn't disclosed in any discovery that I've seen. So
Judges, in the stipulated evidence, I'm just asking him how to explain this in the investigative report. This is all in stipulated evidence already.
Are you saying that this is the same gun that's alleged to have been used? Or the same gun that was used?
That's what I'm trying to inquire into.
All right, so the defense's objection will be sustained until you establish that you're talking about the exact gun that was used in this incident.
Of course, Judge.
Okay.
So the gun that you said you got rid of the day afterwards, was that the gun that you used to shoot Jalen?
Yes.
Okay. And when you got rid of it, according to the report, it was clean of fingerprints and GSR. And you said you had not manipulated the weapon, right?
Nope.
So how is it that you fire a gun and then it's squeaky clean without you doing anything to it?
Mhm.
Magic, right? All right. So you said that Jalen's rendition of events was different.
Mhm.
Previously, you'd already testified that you received no evidence of self-defense from your lawyer, and we have jail calls saying that you did. So you were lying about that to the court, right?
I mean, we didn't talk about it. I just know about self-defense.
Okay. Why should the court believe anything you have to say?
Object, that's improper question.
Overruled.
Why should the court believe anything you have to say, Mr. Pena?
Because I have no criminal record. I have no reason to lie. This is my life against the court. I mean, I ain't trying to do no time over something that I did not really mean to do.
You didn't call 9. I can tell that you don't want to do time because you didn't report this to anybody. You wiped down the gun. And basically tried to cover all this up. Is that about right?
No.
Then why didn't you come forward and tell somebody about it?
Objection asked and answered.
Sustained.
I'll pass the witness, Judge.
Defense.
Nothing further, Judge.
All right. Any other witnesses?
No, Judge.
All right, the court will hear argument.
Judge stays reserved for rebuttal.
On behalf of Mr. Pena, Judge, I'm not gonna re-delve into despite the state's bringing it up again. I mean, clearly the court's aware that my client is of the belief that self-defense was perhaps applicable in this case. Now, clearly on the limited amount of testimony you've had today, you certainly couldn't reach that decision. I'm not asking you to, but that's something that plays in his mind. And I believe the actions of the complainant when he says he was driving down the road and stuck something out the window of his car, to which the immediate response was to my client's reacting. I can certainly see how my client could have the impression that perhaps if instructed properly and educated on the laws of self-defense, we might not be standing here today. But more importantly, I think we can tell from the conversations with my client and the previous gentleman that there was a lot going on that morning. I mean, first, if you read the reports, he passes him and slows down to take a picture. If you hear today, he drives off and then slows down so he can catch him. There's a bad driving on everybody's part, perhaps. But I do know that, my client, as he's told the court, feels terribly about what's happened. He did not intend for this to be the result of his actions. However, it is the result of his actions. He has applied for deferred adjudication. He would certainly like you to consider that application. I would bolster that consideration with the fact that he's never been in trouble for anything. Now, in the event that the court denies his application for deferred adjudication, then I would certainly ask the court, when considering the range of punishment, to look below this 25-year cap. I certainly don't think that in this case, with these facts, that number is attributable to what happened, if you will. Once again, he's never been in trouble. He was part of a incident on the roadway that both of these cars were involved in. Both of them were sticking things out of their cars. I do believe that at that time of the morning, it was still pretty dark out. I think he's an excellent candidate for deferred, but if you do not give him deferred, I ask that you consider the lower range of the punishment. He has been in jail 10 months, almost 10 months, waiting for this day.
I'm good. Good.
All right, that's all I have, Judge.
State.
4 inches, Judge. That is the amount of distance between this being an aggravated assault and a murder. It's 4 inches. If that shot had been higher than 4 inches, Jalen wouldn't be sitting here. He would have been left by Arnold Pena on the side of that highway to die. And even more so, Jalen wasn't even armed. They searched the vehicle. This man shot an unarmed 17-year-old in the face and has the gall to ask, give me deferred so I can walk right on out that door. Even more so, he says that he's justified, but he doesn't do anything to show that he was in the right. He covered this up. He never told anyone. He never told 911, and the gun was cleaned off. And he said he didn't do anything with the firearm, and he put it away a day afterwards. That is impossible without some kind of tampering by Arnold Pena. And further, Judge, I want to go to page 13 and 14 of Sean O'Neill's report. This is in stipulated evidence, and it goes into admissions that the defendant made on his jail calls. And I quote, referring to Jalen, he put himself in danger. At the end of the day, I did what I did, right? And I took off first. They got me with this shit because they took ballistics on my gun when they took it. And that's the only reason why they pretty much know what happened. The callous disregard of he put himself in danger. They wouldn't have caught me if they had done all of this. The only reason I'm in here is because of ballistics. That is not a person that is apologizing and taking responsibility. That is a person who is upset he got caught. I know that Mr. Pena is talking about his 17-year-old, now 18-year-old stepdaughter. Jalen, 17, 18-year-old is 18-year-old as well. And he's gonna have to deal with what Mr. Pena did for holding up a phone for the rest of his life. So, Judge, I am absolutely vehement that deferred is well below what should justice be done here. 5, 10, 15, 20 years is well below what justice requires here. Justice requires that the cap all the way 25 years with the finding of deadly weapon be applied in this case. And that is what I'm going to ask you to do, Judge, to sentence him to the cap, the maximum 25 years with a finding of deadly weapon.
Right. And do parties agree that the amount of restitution is $4,987.42? That's what's in the PSI report.
I agree that's what's in the PSI. I can't state for the veracity of that number, but that's what's in the PSI report.
All right.
4987.42.
And Judge,
So, yes.
I would have to discuss that with Lisa and Jalen about if that's the proper amount. Because I can't, with 6 surgeries, it has to be higher than that.
Okay. Norma,
Yes, ma'am.
recall this. He's going to recall this in 30 days with regards to the restitution. Is that enough for everybody?
Yes, Judge.
Absolutely.
All right. What date?
May 20th? Oh, no. You said
Sorry.
You want to do the June 8th?
Yes, please.
June 8th.
All right. So we'll address the issues of restitution on June 8th. This is what I want you to realize. One, I read everything. I keep an open mind about everything. And I look at the facts, basically what's in the stipulation, and I consider all the testimony that is given to me. And I understand that you have 0 criminal history, right? So I take all of that in consideration, all the evidence that's presented to me. Okay. So this is what the court is going to do. The court is going to find you guilty, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. There's to be restitution hearing on June 8, 2026. There's an affirmative finding of deadly weapon, and the court will sentence you to 15 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I would like to address that.
Yes.
Yes, at the time he signed it, he had no rights to appeal, but having had the motion to withdraw the
Yes.
plea, I have, and I'm going to tender to the court a notice of appeal specifically on that issue. So
Right,
I
and could you
don't
do me a
believe that.
favor? Could you, because the trial court certification, I think was
Can we get a different
originally,
one?
yes,
I would prefer that if you don't mind.
yes, because
Okay.
that was originally signed by Judge Angelini because he took the plea.
Okay.
All right. All right, so the trial court certification of defendant's rights to appeal, you do have a right to appeal. That's related to any type of pretrial motions that were heard and that were ruled upon. And you did have pretrial motions in this case that were heard and ruled upon by me. The motion to withdraw your plea being one of them. You understand?
Yes, ma'am.
Okay. Now, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Okay. And so we'll be back on June 8th to determine restitution amount. Your attorney will be given information on what the state is proposing restitution be. And if y'all can't reach an agreement on that, I'll make a decision, okay?
Okay.
All right, thank you.
And Judge, at this time, I'd like to tender to the court if I could. First, the notice of appeal on my client's behalf, and then secondly, my motion to withdraw solely so the court can appoint him an appellate attorney to handle.
All right,
the-
so
But I'll stay on for the purposes of the restitution hearing. I don't want to delay his
mhm.
appellate rights. Since he's been sentenced today, the
Yeah.
clock starts, so
Yeah.
maybe you can make my notice effective June the 8th or something.
Okay. And can I have the trial court
Oh, I'm
certification?
sorry.
That's okay. What's that? And Norma?
Yes.
Oh, there's no order, but Norma, appointed appellate attorney and see if that appellate attorney can be here on June 8th, whoever it may be, so that you'll have a chance to speak with them at that time.
Thank you.
And then your motion to withdraw,
Just hold
we'll
on.
deal
to
with it
Okay,
after that, yes.
That's fine. Thank you.
There's victim impact.
We done? All right.
All right.
There's a victim impact statement.
Oh, they have a victim impact statement.
Okay.
So on your case, Zavala, he didn't make
No.
transport. All right, recall May 4th.
I was gonna recall potentially judge for Monday, only because I have another client in here on Monday.
All right.
Is that May 4th? I'm sorry.
Yes,
It
May
feels
4th.
like a
Today's
long
not,
time away. and
she needs to sign it.
Okay, all right, see you then.
Sounds good, Judge. Judge, also, family violence wanted to bring something up.
May we approach, since he's still here on an off docket matter?
Yes.
Case of Mr. De Leon's client, Mark Ruiz, was set on the jury trial docket on May the 12th. We have a motion for continuance, Your Honor. We would like to argue that we have an essential witness who is unavailable that week at our sane nurse, Miss Shannon Murphy, who is on an approved vacation for that week. She is an essential necessary witness as she is looking to complete the defendant's SANE exam. And she is essential in that she's needed to establish the first link in the chain of custody for any DNA evidence that will be entered into.
And is there DNA evidence?
Yes.
Yeah, there is.
Okay.
Judge, I can tell you the court that I have a murder trial on 437 set the same day. Specially set, so I'm not jumping in up and down opposed to the defense's, the state's motion.
All right. Well, is your client is on bond, right?
Yes.
All right, so if you want to have him by Zoom on Monday, because he has to be here for me to rule on it.
Okay.
And then I'll take care of it.
Good.
All right, thank you.
Thank you, Judge.
You're welcome.
Good, man. Approach.
Yes.
Jalen has so long ago talked to him.
All right, who's ready? Judge, there's a plea up there. Williams, Angela Williams?
Angela Williams.
Ready, ready.
Revelis. Revelis, did you turn in paper? I just need to approach for a continue.
Court is calling 2026 CR 0000269 State versus Angela Williams. Can I have parties announced for the record for the state?
Lauren Esposito for the state.
Roger Bettis for Miss Williams, Your Honor.
And are you Miss Williams?
That is correct, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Miss Williams, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I believe, Judge, we are proceeding on the lesser included offense of attempted
It's a
injury.
class A misdemeanor.
No, I think you all are just proceeding on assault bodily injury.
Oh, yes, Judge, we are proceeding on assault bodily injury. Apologies.
No problem. And I understand you're probably not the one who worked out the plea.
No, Judge.
So I only know because I'm reading the admonishments. Any objection?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, but could I ask you a question?
Sure.
What you just said to violate, assault to violent injury, what do that mean?
Do you want to talk to your client about that?
Yes, Your Honor.
All right, do you understand it?
Yes, Your Honor.
And has your attorney explained that to you sufficiently?
Yes, Your Honor.
All right, so the state is proceeding on the less included offense of assault bodily injury, assault causing bodily injury as a class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe so.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. Punishment is to be assessed at 1 year in the Bexar County Jail. There's an $800 fine, and the state is recommending community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense of state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing it, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with the complainant, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, as to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. Proceed on receipts exhibit 1 and all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, the gentleman that was involved in this is a neighbor. They had a relationship over time. There was a issue pertaining to the taking of certain items. And that was what the issue was, what the misunderstanding was. She's 57 years old. She's disabled. She's been a certified nursing assistant since she was 20 years old. This is the first issue that has ever risen in her life. She's a very pleasant person. Her nickname is actually Queen. And we would just ask that we would be granted the probation. And if you could consider, she's not the most physically mobile person. So we believe that, and nor does she have the ample resources because she receives a check. If you could consider lessening the fine and the community service, Your Honor.
All right. This is what the court will do. The court is going to sentence you to 1 year in the Bexar County Jail, suspended and probated for 1 year. There's an $800 fine that will be probated. There's to be no contact with the complainant. Probation, that. Thank you. There's to be 200 hours of community service restitution. I'm going to order anger management. Once anger management is completed, do you have any grandchildren that stay with you?
No, I live alone, Your Honor.
All right. Once anger management is completed, the community service hours will be deemed satisfied. Regular reporting by Zoom or in person, regular UAs. Do you receive SSI or?
Yes, Your Honor.
All right, proof of SSI within 45 days. Field visits 1 time per month for 2 months. Probation, is there anything else?
No, Judge.
All right, do you have any weapons in your home?
No, ma'am.
All right. So there'll be no possession of a firearm.
Yes, ma'am. Yes, Your Honor.
Is there anything else you need from the court to be successful?
Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes, Your Honor.
All right, good luck to you, okay?
Thank you.
You're welcome. All right, the parties on the person with the engagement ring.
Yes, Your Honor.
All right, you all asked me to reach out.
Mhm.
I have reached out. So the ring is a white colored ring with white colored stones. And I'm assuming, is that the ring?
Yeah, there's picture, we have pictures of it, right? It's kind
Can
of,
I
an in-
talk to the complainant real quick,
Sure.
Judge?
it's an interesting engagement ring that
Mhm.
kind of like comes apart in a weird way.
Morning.
Good morning. So you all have a photo of the ring?
Yes, ma'am. May I?
Yes. All right. Do y'all mind if I take a photo of this and send this and find out if this is the exact?
No objection.
No objections, absolutely.
Let me see.
Now for a second, wait, that's a photo of a photo, so we gotta authenticate the photo. Close up, no. Don't get into the rules of evidence.
We don't need to. Oh my goodness.
It's the wedding band, the engagement band, right? Okay. And Judge, just wanted to reinforce that it's 2 rings. It's the engagement band and the wedding band that we're trying to reacquire.
So is this the total of the engagement and the,
No, ma'am, the photo that I handed over is.
It's just the engagement?
Yes, ma'am.
all right, because sometimes I know it attaches.
Yes, ma'am.
Let me ask.
Wife actually never got like you got the engagement band, and she loved it so much that she never got like the wedding band. So we're just like, okay, eternal fiance.
Thank you.
Right, so this is what needs to happen. And I know this is a never ending story, but
It's a little
my
like Lord of the Rings.
understanding,
Yeah.
You all want the engagement ring back?
Yes, ma'am.
All right, so that's in the property room. Now, it is the inmate's property, right? Because it came in with him. So an order needs to be filed. And maybe whoever is that, does anybody know who that inmate's attorney is?
So he requested one. They haven't appointed him one yet, so he doesn't have an attorney. And
Which court is it out of?
175th. But I don't know if they're gonna get to it at all because he's dealing with the feds right now.
No, they should still
I mean,
appoint him an attorney, huh?
they should, but
He has to be appointed counsel.
Because here's the thing. That ring.
That maybe you could.
Oh, let me just tell you. Let me get the other attorneys who've been waiting. Who are you here for?
Judge,
Yes.
sorry, we had a compliance hearing that's.
Oh, yeah, let's do the compliance. Come forward with the compliance. Who is that?
It's Albert Gunther, Judge. And Ms. Gay has been appointed to Mr. Gunther, Judge.
Oh, awesome.
Good
Mr.
afternoon,
Gunther,
Judge.
how's it going?
I'm doing good. How are you?
Oh, I'm doing okay. At least it's not 5:30, so we're all doing good.
So Judge, we're here today because we received an order for transfer from felony drug court. At this time, Mr. Gunther does not want to continue participation in felony drug court and is voluntarily withdrawing. There were some concerns that he has spoken with his attorney about, that we probably just want to talk through everything.
Because according to the ruling, there was a violation of condition number 2. The court found it true, referred you to felony drug court, and if not accepted, then you were to go to SAT.
So Judge, he has been a participant in felony drug court since December of 2025.
Okay.
He was ordered lifetime recovery inpatient. He entered lifetime on December 31st of 2025 and completed that on the 30th of last month. He was then transferred over to a sober living facility, but some issues arose at that sober living facility in which he was evicted. And then I think that's where we are now.
Okay.
better than he looked before.
Oh, no, he looks great.
And
Yeah.
we, with the intensive supervision, you know that we do check on them very often. And if there are any issues, we will implore Mr. Gunther to come forward and if he needs additional help.
All right. And let me just tell you, I want to commend you because there are some people, when they hit a bump in the road, they just disappear. Whether it's their fault or not their fault, sometimes they're like, oh, life is bad. They throw up their hands and just call it a day. So I appreciate you're not doing that and trying to say, okay, here I am. Maybe I was treated badly, because you know that happens in life.
Yes.
And how you respond to it tells me where you are in your sobriety. So thank you for that.
Thank you.
All right. So is there anything else you need from the court?
Just your help whenever I need it.
All right, awesome. Okay, so once you sign those amended conditions, you are done today, and thank you for your patience today.
Thank you. And today is my 7-month sobriety.
Oh, congratulations. That's a lot, right? Oh, no, I always tell everybody, every single day, each day is a day. So congratulations. All right, thank you. Just give me a moment. Let me put this in here. Can I run to the restroom, Judge? Oh, yes.
Ready to speak more on chambers whenever you're ready.
Sure. Who are we here? All right, do you have the motion to quash?
Thank you. I was gonna lend you my copy. I appreciate that.
Okay, I'm so sorry. Just give me one moment. Let me just do a reset real quick. All right, who's for the reset?
Ravello?
Yes. Okay.
They were looking for it.
Okay. And what page is this on?
He's on page 7, toward the bottom.
Ah, so what is happening with this case?
Judge, we just got the initial offer. I reviewed it with my client. He'd like an opportunity to contemplate it.
All right, do you have all discovery?
I believe everything. I believe we have everything.
How old are you?
23.
All right, Ms. Ferguson, recall this in 30 days for plea deadline date.
Yes, that'd be May 28th.
All right, thank you.
Thank you, Judge.
Keonis. Court is calling 2026 CR 00067 State versus Victor Keonis. Can I have parties announced for the record?
Brandon Freire for the state.
Afternoon, Judge. Robert Gear for defendant Victor Quinones. We're ready.
Oh, I'm so sorry, Cindy. I know you had left, but now I thought you had come in. All right, court is calling 2026 CR 00067 State versus Victor Keonis. Can I have parties announced?
Brandon Freire for the state.
Robert Gear for defendant Victor Quinones, and we're ready.
And are you Mr. Keonis?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, we did, Judge.
Court will find that the state is in compliance with discovery. Mr. Keonis, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Keonis, did you review the true bill? I'm sorry, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he was and is.
Mr. Keonis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years in the prison. There's $1,000 fine probated, and the state recommends community supervision. Did you understand that to be your plea?
Yes, ma'am.
State defense?
Yes, Judge.
That is
Did you-
true, Judge.
Did you review that's okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
There have not been, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be 100 hours of community service restitution. No contact with Herlinda Hernandez, the DOEP course, and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Judge, we offer state exhibit number 1 and all attachments.
Defense is reviewed, Judge. We have no objections.
Did you review the state, you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge, and we'll waive a PSI.
Anything you wish to say on behalf of your client?
Judge, the defense would respectfully request that the court follow the plea bargain.
All right, do you have any children?
No, ma'am.
All right, do you live by yourself?
No, I live with my sister.
Does she have any children?
No, ma'am.
Are there any minors in the home? All right, there's $1,000 fine to be probated. The court will sentence you to 3 years in the prison, suspended and probated for 3 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 35 days of release. No employment as a home health care provider or with minors. No contact with Herlinda Hernandez. TAP evaluation out of custody, follow TAP recommendations. No residing in households with minors. Field visits 1 time per month for 6 months. 100 hours of community service restitution. Court will deduct 50 hours upon completion of the DOEP course. The remaining 50 hours will be deducted at 1 hour for every sober support meeting completed. Probation, is there anything else? Ah, yes, okay.
He said 45 days, nothing else.
All right, thank you. Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Jessica Navarro.
Data said that it may be used.
Yes. Norma, did you have any contact with Mr. McLean? All right, if you'll come forward, please, Jessica Navarro. Hi. All right, so are you employed?
I just got a job.
All right, are you able to Zoom?
Yes.
All right, so what are we gonna do? Your attorney is out of county. I've just been informed of that now.
Okay.
We're gonna recall you back for next week, Thursday. And if you can Zoom in,
Okay.
you'll be allowed to Zoom, okay?
Okay, would I get the,
They're gonna give you the link and everything.
okay, thank you, Your Honor.
All right, thank you. They're gonna give you a reset form, okay?
Yes, ma'am, thank you.
All right, the people on the ring. I'm just calling it the ring. We're gonna try to get your, I say we, they're gonna try to get you the engagement ring back. So of course, there are other things now that happen. Now everybody knows where at least the engagement ring is. It appears that it's not the band as well, because they only said one ring, or sometimes people don't know. So we're gonna recall this back in May. It should be easy for somebody in property crimes.
Yeah, I would think it's beyond the scope of us, at this point.
Let me just tell you how it should work legally.
We will see.
All right.
So is there anything that you would like me to file in terms of the court doing an order, or?
No,
or
I mean,
leave it in the hands of
it'd be the
the
same
property
thing.
crimes?
basically the police has to do it unless that person gets an attorney. And so it's out of the 175th. So they should assign him attorney for the case that he has here in Bear County. Then that attorney can talk to him, but
I'm sure you couldn't be assigned to it, because that would be.
No, it'd be
Oh, that's a
way too-
conflict.
way too much of a
Yeah.
conflict.
right. So Norma, let's call this back on May 28th. You all should have the ring by then.
We will see. We have one ring, we'll have we know where one ring is, we'll see where the other ring is.
Well, yeah, actually, do the rings come apart at all?
Yeah, there's a.
Yeah, they're separate
They're
bands.
separate bands.
Yeah, so one band is in the property room and the other band is with Bonnie Doffler.
I think the judge just read that he only had one ring
Yeah,
the whole
two
time.
necklaces in one ring, I think.
Well, they're just saying it's one ring.
Oh,
Maybe the ring's on the necklace, that's what I heard.
yeah, I think I remember you telling me that, so we'll find it.
So I tell you what, though, and that's Bunny with an IE.
So
BONNIE.
BONNIE and then Davila.
Yes.
Okay.
All right, thank you.
Perfect.
Thank you. All right, just one second.
This is all that guy to me, what he's afraid.
All right, and Norma Andrade report is being recalled on Thursday, correct? Page 4.
Page 4, give me one. Yes, yeah.
All right. And then Charles Smith with Rocha, that's on.
I just put the motion for continuance right there.
All right. So let's call this back for the 7th as well.
Seven? Thank you.
Mhm.
And Tony's ready to coach Tuesday.
All right, just a second. All right, your case now. And where's Mr. Pearson?
We requested if you were attend by Zoom or doing
Yes.
allow him, and he should be on.
Okay.
I have your number now, so I'll text you back.
All right, Mr. Pearson. Mr. Pearson. If you could unmute, please.
Yes, I'm here.
All right, could you show your video?
Yes, sir. Just a second. Okay.
And on these cases, I need to see the indictments, please. All right, thank you.
Right. I'm sure these would go.
Thank you.
Mhm.
Thanks. All right, the court is calling 2025 CR 008217, 2025 CR 008219, 2025 CR 008221, State versus Pearson. Can I have parties announced for the record?
Warrant Espinoza for the state. Monica Anna Guerrero for Pearson.
All right. And are you Mr. Pearson?
Yes, ma'am.
All right. Defense, do you have any objections to your client appearing by Zoom?
No objections.
All right. In each of these cause numbers, the defense has filed a motion to quash the indictments. State, have you had a chance to review the motions?
Yes.
All right. And State, are you objecting to the motion?
I suppose so, Judge. For full disclosure, I talked with defense counsel earlier today. I did file a motion to amend said indictments, adding a time at approximate 7 p.m. to each indictment. I just wasn't sure what the order was of proceeding, if we proceed with the motion to quash or just motion, I don't know. I think she objects because it was within 7 days, not 10, so yes, I object to the motion to quash, but also I don't know if I'm to urge this, I guess is.
Oh, okay.
Disclosure.
All right. So where we are now is we're just dealing strictly with the motion to quash because she doesn't have proper notice of the amendments.
Hey, Judge.
So with regards to that and not having the amendments, State, do you believe that a motion to quash and the granting of that is appropriate or no?
No, Judge. No.
All right. So I'll hear your argument, counsel.
Sure, thank you. So as the court and the state are aware, we have been before this court several times because of Mr. Person's mental health at the time of the incident. And specifically, we've been referred to two mental health treatment or two treatment courts that have been denied by the state. Mr. Person's culpable mental state at the time of the incident is really at the heart of this case and this motion. This case arises from a night on November the 13th, 2024, where Mr. Person was having a severe mental break in the town of St. Hedwig, this outside of the San Antonio city limits. It borders Converse. Mr. Person and his family lived at the very back of the neighborhood it's a new construction neighborhood called Abbott Place. And it was on a dead-end street facing undeveloped fields with trees and pastures and even ponds out in the fields. The day after this mental health crisis, two complaining witnesses in his neighborhood of Abbott Place at 13693 Paxton Boulevard, as named in the indictment, and at 13689 Paxton Boulevard. Those one other complaining witness in the neighborhood judgment, yes.
Okay, all right, let's
Okay.
continue.
So, and then, to round that out, there are three complaining witnesses, and the complaining witnesses and Mr. Pearson don't know each other. That's background for the court. With the court's permission, I would like to show, and I've showed these to the state, just a map so the court can get a bearing of what we're talking about in this case. If they're two Google Earth maps, I'm not presenting them as exhibits, just for judicial notice and for the court's perspective to be able to.
I mean, I feel like that's going a little bit outside the scope of a motion to quash. The motion to quash purpose is to say that the charging instrument is deficient, so I'm not sure
It's
the
for
utility of the map.
I'll get there. It is for background. That the heart of this motion is, the heart of this motion is that the state has failed in their indictment to plead with sufficient certainty, with sufficient notice to give the defense an opportunity to prepare adequate defense of the culpable mental state of knowingly. The state is required to plead that the defendant, that Mr. Pearson knowingly discharged a firearm at or in the direction of a house.
All right, so
And yes,
this is what I'll tell
yes.
everyone, my understanding of the law and the motion to quash. Any facts about whether or not the area where he's alleged to have committed any type of offense, and I'm not saying that you committed an offense because we're
Yep.
just hearing the
Right.
motion to quash. Any evidence of whether or not a location was abandoned or whether it was intentional or reckless, those are fact issues. With the motion to quash, my role is to look at the indictment and look at the four corners of the indictment and see if the indictment gives sufficient notice, if that's what your argument is. But it's not to figure out the facts, like, was this an abandoned place? Was this on the outskirts? Was it new building and nobody would be there? That's something
I
for a
understand.
jury.
And I'll try to proceed and stick to just the four corners.
Sure.
And that's exactly the problem that I've had with this case from the beginning in 2024 when I received the case. Is I've been raising the same issue as to what circumstances, how and by what means and manner does the state have to show that Mr. Pearson knowingly discharged a firearm at or in the direction of a home. What the state has pled in the indictment, and they are allowed to track the statute, yes, to a certain degree, but they cannot just regurgitate the statute. And what Rodriguez v. State calls and I have the opinion here, is a tautology. The indictment cannot state, and that this was actually a deadly weapon case coming out of San Antonio, I believe, that addressed the reckless deadly conduct. And in that case, the court held in that case, they struck down an indictment because basically what the state had pled was that the defendant recklessly discharged a firearm because he discharged a firearm. And in this case, that's all that the indictment says here, is that Mr. Pearson did knowingly discharge a firearm at or in the direction of a habitation and was reckless as to whether the habitation was occupied, namely by or because he discharged a firearm at a habitation. There's a circular argument, or it's a circular allegation that gives me as a defense counsel and defendant no indication of what knowing conduct, just because a home may have been struck by some kind of gunfire, does not get the state to, does not establish the mental state that the state is required to provide. And we don't have a notice of what evidence there is, and that's been my question all along. Not even what evidence, but what circumstances, what means and manner, other than the fact that the defendant, as they allege, discharged a firearm, as they allege, at habitation, because he discharged a firearm at habitation. It sounds very confusing, I get it, but I don't have anything other than, I don't know in what way he fired he would have fired a discharge of firearm at a home, at this home, and at this home in various different locations and in the ways they were. And that's why I was trying to give the court some background as to, I don't have no notice on what the state is going to, what the state's basis is for knowingly.
All right, thank you. All right, state.
Yes, Judge, the state will concede that generally an indictment or information is sufficient when it tracks the statute. Now, there is an exception that exists when an offense or a statute prescribes the mental state of recklessness or criminal negligence. At that point, the state is required to put a manner and means and needs to be more descriptive. So here in this case, we have the charge that requires essentially two different culpable mental states. So we have the first part of the statute that requires knowing discharge of a firearm at or in the direction of, and then it gives A or B. Here it's under B, which would be a habitation. And then the second mental state and is reckless as to whether that habitation is occupied. The aspect of knowingly, Judge, is how he knowingly discharged is shown through evidence. That's for the fact finder to determine. Whereas the element of recklessness, as the code tells the state we must do, we are to allege manner and means of doing that. And we've done that here. The state judge is not required to allege evidentiary facts in a charging instrument, and we're not required to lay out its case unless it falls into the required mental state. So defense's argument of we are not properly alleging how he knowingly discharged, that would require us to lay out our case, which we're not required to do, but we do have the requisite manner and means regarding the recklessness element, culpable mental state of the fact. So because of this, Judge, we would urge that you deny defense's motion to quash the indictments as they are sufficiently pled.
And I would disagree with it. There are two prongs to it, that he knowingly discharged firearm out in the direction of a house, and he was reckless as to whether the habitation was occupied. But other than, there is no manner and means for reckless either. And she is right, there is a higher standard for recklessness for them to provide circumstances surrounding that mental conduct. But as to that, there is absolutely nothing in the indictment that goes to the reckless, a reckless disregard of whether a habitation was occupied or not. Also, with regard to Rodriguez, the case that we discussed, it sets a floor for that tautology argument that it cannot be circular. And then further, the Constitution, the Texas Constitution and the US Constitution allows us notice and certainty as to the alleged culpable mental state. I just have nothing to go on with this. I really, and I think it's telling that the state did actually file a motion to leave to amend their indictment, and they only added, their proposed amendment is to add a timestamp. That doesn't go any.
Oh, I'm not even looking at the amended.
But I would like to say it is important that they have moved, they have asked the court for motion for leave to amend. That being said, even if it was granted, we would object again. I know you're not addressing that, but that does go to the heart of our case, and that something needs to be in. I need more notice of how we're going to put on a defense of this case of that he knowingly shot at or in the direction of a house, and that he was reckless as to each habitation being occupied or not. And for these reasons, we are requesting that the court quash all three indictments. The indictments allege that something happened. They don't allege that Mr. Pearson knowingly made it happen and that he was reckless.
Okay. All right. State, the defense has tendered case law. State v. Rodriguez, if you want a chance to continue present case law, you're more than welcome to do that. And if you all present what, if there are other case law you all want me to review, let me know. And I will give you all time to do that. And I will, when is a good day for you to come back, counsel? And of course, your client can appear by Zoom.
Okay. When are we thinking, what kind of timeline are we?
Oh, no, just let me know whenever, if there's more information you want to present to me, any more case law for me to consider,
Okay.
just let me know.
Yeah, absolutely. I'd like an opportunity to explore the case law some more help, 10 days.
Oh, sure. And if you'll share this with the state.
Is that what you just? Yeah.
Oh, you already have that. Okay. And then if you all want to, both of you all have my email. If you want to send it by email, but when you're sending by email, just make sure all parties are included. And if there's more case law that you want me to review, I'll review it and then make a decision.
Okay. All right.
All
So
right.
it's set for to come back in 10 days for your
Oh,
decision.
if that's enough time for you all.
Okay.
Yeah. Because I know sometimes people are like, oh, Judge, we want you to consider something else. So if there's something else
Okay.
you want me to consider, I'll consider it.
Okay. Thank you, Judge.
All right. So Norma,
Yes, ma'am.
they're asking for 10 days. And Mr. Pearson, thank you so much for your patience.
Yes, ma'am,
It's been a
absolutely.
busy day today, and there were some cases that had witnesses, so.
Yes, ma'am.
Can we put it on May 11th?
Is May 11th enough time for you all? I know how it is to be a defense attorney. You don't have an appellate staff. You are your appellate staff.
Yeah. Yeah, I think 10 days is plenty.
All right, so May 11th, that will not be the upcoming week, but the following week, and that's a Monday.
Okay.
So that's enough time for everyone?
Yes.
All right, so each party, just for my benefit, the last day that you send me case law, please let that be May 8th,
Okay.
and then I'll look at it over the weekend. All right.
Thank you, guys.
All right, thank you.
Thanks.
All right, Mr. Pearson, you can come back. It'll be the same link, and we'll have you back on May 11th.
Yes, ma'am. Thank you, Judge.
All right, you're welcome. Oh, and then defense. If for some reason I don't rule in your favor, if you'll be prepared to hear her motion to amend. And if y'all have case law you want me to review on that, you're more than welcome to submit that as well.
Perfect. Okay.
All right.
Thank you.
I haven't made a decision, but I just want everyone to be ready.
Do I need to file? I think I objected on the record. Do I need to file a written objection? Okay.
No, just make sure that it's clear on the record.
Okay. Thank you.
All right. Who else is next? Tony?
Yes.
Who is your client? Number, what page is Tony's client on?
It is short your file.
Oh, I see it. What is happening with this case, Tony?
I pulled up, I'll just start, I looked into it and I pulled up the case. We are missing a few documents from DPS, so I sent a request for those and I will review and give Mr. Hernandez an offer ASAP.
Okay, so.
In addition to that, Judge, we had filed a motion for bail reduction that we had conferred about. Satan and I had conferred about.
As for that, I would just defer to the court. I did explain to Mr. Hernandez, his client would need to provide testimony about what he can afford.
All right, let's come down. And Norma, recall this in 30 days for discovery.
One second. I was in the middle of something. I'll give it to you in just a moment, Judge.
Okay, all right, the court is calling 2026 CR 002694 State versus Brian Ruiz. Can I have parties announced?
State.
On behalf of Mr. Ruiz.
And are you Mr. Ruiz?
Yes, ma'am.
All right, we're here. The defense has filed a motion for a bail reduction. Your bond is currently set at $40,000. State, have you had a chance to review the motion?
Yes, sir.
All right, and State, are you ready to proceed? All right, defense, you may proceed.
Your Honor, we called Brian Keith Reed.
Can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Brian Keith Breeze.
All right, you may proceed.
Brian, you understand that you're currently being held on a $40,000 bail, or bond, is that correct?
Yes,
Now, you have on your own previously filed writ of habeas corpus seeking bond reduction, is that correct?
yes,
Recently, your mother hired me and asked me to assist you, to represent you and to go forward with this bond reduction, is that right?
yes,
Okay. You and your family have made attempts to make this $40,000 bond, is that correct?
yes.
And my understanding is that your family has reached out to different bondsmen, and what is the response that they've received?
They want 10% of the 40,000 and they want collateral, some kind of deed to the house or car title or something like that.
Now, your mother is in Houston, Texas, is that right?
Yes.
Where she lives?
Yes,
And is she on a fixed income?
yes, she's retired.
Is she able to assist you in getting money together for this bond?
She's trying, but she can't afford 10% of 40,000.
In fact, she's indicated that she can get another $500 together. Is that about right?
Yes,
But she is not able to come to San Antonio and sign off with any bonds. Is that right?
yes.
Now, you do have some family here in San Antonio, right? You have two daughters. that are
My two
adults.
daughters.
And how old are they?
My oldest one she just turned 18 and my youngest is 16.
So the 18-year-old, does she own any real estate?
No,
Does she own any vehicles, or
no,
to your knowledge, does she own anything that she could borrow in order to raise money for you?
no,
Now, do you own any real estate?
no,
Do you own any vehicles?
no,
Okay, do you have any type of property that you could borrow against or sell in order to raise the $4,000 for the bond?
no.
Now, you've been in jail since December 28th, is that right?
Yes,
And what kind of work were you doing prior to your arrest?
carpentry, construction, remodeling, landscaping,
Were you-
handyman type work.
Did you have any employees?
I work for my neighbor and some Donnie Horderman off and on, and then some of my neighbors, I do their landscaping.
Okay, but you were working for them, right?
Yeah,
They weren't working for you.
yeah, I'm work.
Okay. And obviously, you've not been able to work since December 28th, is that right?
Yes.
Okay.
Because I've been in jail.
You were originally appointed an attorney, so you filled out the application and you were determined to be indigent and fine, is that right?
Yes,
Fair to say that your monthly living expenses are equal to or less than your income, is that correct? When
Yeah.
you're outside?
yes.
Okay. You're asking the court to reduce the bond. How much money do you think you and your family what size bond can you and your family?
10,000, maybe? Maybe,
Something along that line.
yeah.
Okay. We'd pass it in, Sam.
All right, any questions?
Just a few. Hi, Mr. Ruiz. My name is Lauren Espinoza. I just have a few questions for you, okay?
Listen,
Regarding bondsmen, have y'all shopped around for bondsmen, or did y'all only go to the one that required 10%?
but my mom, she was calling around, so I don't know exactly how many she called, or if they were wanting title to the house or title to vehicles
So
and
you-
co-signer.
So you know more than one she tried.
Yes.
Okay. And then regarding your family members, do you know them to have any savings accounts?
My daughters, I don't think so.
Okay, no further questions, Judge.
All right,
Thank you.
any further questions?
No, Your Honor.
Any objection to the court asking a few questions
No,
for
Your Honor.
purposes of perhaps setting conditions?
No, Your Honor.
All right. Have you ever had any type of mental health diagnosis?
No, ma'am.
All right. Any type of drug use in the past?
No, ma'am.
Okay, no marijuana, no alcohol,
Smoke weed occasionally and drank some socially.
all right, but nothing that you would consider rising to the level of an addiction?
No, no.
All right. And if you were able to make bond, who would you be staying with?
My dad's house. He passed away and left me the house.
All right, any minors in that home?
No, my daughters live with their mom, my ex-wife.
Okay. All right, any other questions?
No, Your Honor.
Any other questions? Okay. Any other witnesses?
No, Your Honor.
All right, state any evidence?
Judge, we just have the prior history of Mr. Ruiz. It is 2 state jail felonies and a misdemeanor criminal mischief. But other than that, I don't see anything else.
Okay. All right, and the defense is asking that bond be set in $40,000. State, are you in agreement to reducing or no?
I don't necessarily object, Judge. I defer to the court.
All right. This is what the court is going to do.
If there's no sidewalk, depending on the street size and stuff.
All right. This is what the court is gonna do. Court is gonna set the bond at $10,000. Anything else?
Oh, we got it.
All right, Norma, what date for them to come back?
28.
All right, we're gonna come back on May 20th. You need to make sure that you're on time.
Yes,
And if there's a sidewalk provided, walk on it. If there's a sidewalk provided and you're on the bicycle, you're not allowed to ride on it.
And lights on the bike.
And lights on the
Yes.
bike. All right, so,
Yes.
so if you'll sign that and you will be back then.
Okay, thank you.